Yes, I mean.
Yes.
I beg to mention item number 6.
Item number
6.
yes.
With a consent of other side, may I pray for listing of matter after 3 weeks.
3 weeks. 3 weeks. On the prayer you have for
I am for the
respondent, private respondent,
my lord.
private.
Okay.
You argued a case. So far, I remember before division bench relating to the subject of par inquiry. You argued. Can you give me the judgment? Do you remember the matter? Or you can give the number to her. I'll get created the order. Not now. After something. We'll admit this.
Yes, ma'am.
He's appearing for whom? Okay.
My lord,
Well, let me examine. It needs examination because the vital issue is there whether by an IA a dispute of writ petition can be reopened.
My lord, my respectful submission.
Okay, then if you want to
Yes.
go for hearing, you proceed. We thought that we'll admit and fix it for hearing. Or you want objects in the admission itself?
My lord, my only one
Yes.
after this is
Yes.
after the
No, no, you are free
Yes,
to
yes.
argue. We have no problem.
My respectful submission is that even in the IA,
Hmm.
it is not entering into the merit of the judgment.
Hmm.
It is there was only confusion. Confusion.
Let us see the earlier judgment first.
Yes, my lord. In my IA also, I have categorically stated that there is a difficulty in implementing that order.
No, we do not see any difficulty.
My lord, may kindly come to
The earlier first
page
judgment.
14, page
Page
15.
Page 15.
May I read, my lord?
Yes, you read it.
In view of the above, the instant writ petition is disposed of by directing the state respondents to take immediate steps to release of the outstanding balance of such and such. The amount be released as expeditiously as possible and in any case within an outer limit of 6 months from the date of receipt.
Where are you reading?
Copy.
Page 50, page?
Page 15, my lord, of the IA.
No, is it a part of the writ appeal?
But I have not been provided with a copy of the writ appeal, although my name is reflected there.
Oh,
So I'm
then you-
relying on the.
No, give a copy. Yes, Mr.
IA is already disposed of.
We have already disposed of. Okay. No. IA is.
Who is the order? Page 82. My lord, this order, subsequent order, is related to the second part of this paragraph 5. Failure on the part of the state respondents to
Where
make
is that
payment.
order, earlier order?
My lord, at page 83, my lord.
Huh?
Page 83.
Page
83.
83.
My lord, the paragraph 5, the last 3 lines, my lord. Failure on the part of the state respondents to make the payment within the time frame by this court would entitle the petitioner to approach the appropriate forum for payment of further interest.
So therefore,
My lord,
it is no unambiguity that there is you
But-
can approach
My lord-
appropriate forum.
My lord,
The court has not said writ petition, number one. Now therefore, appropriate forum is directed. You have approached an appropriate forum by filing a civil suit.
my lord, may I just complete my submissions, my lord? Well, there are two issues here. One is from which date the interest will be calculated.
Hmm.
And secondly, what are the interest rate of the interest?
Hmm.
Because this is not as money issued. So therefore, there is no specific provisions that in such a case, the rate of interest has to be in such a manner. Had it been a money shoot, and post pre and post shoot would have been covered by section 36 of the CPC. But then since there was a confusion, and therefore only for a clarification or elucidation of this direction, this was filed. And accordingly, his lordship, the London single judge bench, merely explained the intention of the court only. So my respectful submission is that this is not entering into the merit of the case. It's not reopening of the.
We have reservation on that. Therefore, we want to admit this.
But otherwise, allow this writ appeal. We will fight it out in the lower court. Already, our application is pending there. But an issue will be, from which date this will be counted.
That is a factual assertion. See, that's why we are saying this will be a factual assertion on which date you have served a copy, from which date that it will start, the clock will start clicking, and what should be the interest entitled.
Otherwise,
If they can make explanation that there was no fault on their part, it is you for whom there was a delay, there may not be any interest. Can that be decided in a writ court? That's why it was directed before a forum. This is the difficulty.
yes. Now, otherwise, my second submission is that allow this writ appeal.
Do you record that?
Yes.
Okay.
Because even after admission, the same issue will come up, and it will be just wastage of time. So already
Of course.
12 years pending bill, man.
So you go for
Only
a-
my respectful prayer is, to if it can, lower court could be advised to proceed study in a regulated manner, and then civil suit to dispose of the case as early as possible.
No, that we can express our wishes.
Yes.
Supreme Court has said, please don't issue direction to the courts to fix it within a period,
Yes.
because you do not know how many matters are pending in the court. You can express your wish that we will expect that learned trial. That much only. So we'll not go to the merit. We'll say that
No problem.
no merit. We'll not go to the merit. That's all.
Otherwise, it will take hearing.
Okay, dispose it of. With a liberty to continue with the civil suit already filed.
Oh.
And we'll express our opinion.
104.
Huh? Give the suit number.
Money shoot number 104 of 2023.
Money suit number 104 of, just write it down. Anything you mention somewhere?
I'll give it. No, when I put
No,
it.
nothing. Rate of interest will be decided by the trial court. Trial court can decide, we'll make it clear. Because it will depend for whose action, what is the gravity of the inaction. On that basis, they will, whether it can be given at the market rate, in the compound interest, that is to be decided by the civil court as per pleading of the parties. So impugn order we are setting aside.
Huh? One is the rate interest, and other one is going to from we take it into the calculated. So far, from we take it into the calculated, we are not agreed by that. Our appeal is against the rate of interest. To that extent, my parents.
Do you say that we are willing to pay some rate of interest and there is delay on your part? Please say we'll dispose it of modify the single judge's order.
Yeah.
Why should we send a party to a civil court?
I'm paying for the
6%.
because
No, that cannot be quantified by the court. Because as I have
We
submitted.
cannot quantify this
Yes.
code. What he is proposing is, see, since we have not challenged the earlier order whereby interest was made payable on a date from which after expiry of the period as directed by this court. According to them, we will pay interest from that date. From that date, expiry of that date. This is, they have agreed. And other parties, they are saying we are ready to pay 6% interest. Why should you fight in the civil court for years? Take 6% and finish it off.
But in
Where is your
my,
statement regarding that?
in my
That
suit,
6%?
I have claimed for 8%.
The petition should proceed for
Apart from the interest of the lawyer, it is not appropriate to comment also. Think about
But
the,
if you
think,
lordship sets
about
sets a
the
time
lit-
bound,
think about the litigants.
Lordship, can I see once my lordship prayer?
Hmm.
To this extent, if this is part, allow this is.
You are here for litigants.
So that's fine. See, if 6%, tomorrow civil court may not grant you 6%. Where is the now the interest rate is banking rate is 2%. They are very good that they are offering 6% to you. Where is your statement?
You should be happy, in fact.
You should be happy.
my only otherwise my only respective submission is a time frame may be fixed then again.
No, of course, they will give a time frame, but only difficulty is that we are worried. Tomorrow, his clients don't say that you don't have any authority to make this submission.
But it is his statement.
He will be in a trouble. You do not know these officers.
So as
The statement is not there.
Where is your prayer? Where is your prayer? Where is your prayer?
Page 8. Page 8.
Page 8. In the writ appeal.
This is my lordship, the simple prayer. To this extent, it is allowed lordship, can be.
But there is no statement that we are agreeable to these extent.
yes.
What else?
Lawyers' concession is difficult
Yes.
because we have to file an affidavit. Huh?
Yes.
But in paragraphs,
You ask the
My lord,
competent authority to file an affidavit that 6% you will give an interest.
my lord, otherwise in page 7, paragraph 6, page 7, they have slightly indicated that word 6%.
Paragraph.
6, page 7, my lord. Although this is not direct admission, but then I also haven't read it, but let's just be disposed of as
To file an affidavit by this officer.
Here lordship,
See, we do not want a review once again. That some official comes say that we did not have any instruction to make such submission, then it will be a difficult proposition for you as a lawyer and for us also. So there is an affidavit by this Tara Takia, who is he? Deputy Director, Food and Civil Supplies. Ask him to file an affidavit.
lordship, without recording my assets.
No. How can we are?
In rich petition, there is no.
Don't put all this burden on us, as simple as that. If you want to give a concession, give it on affidavit, or as he has pressed, we will close his on his submission with a liberty to continue with his civil suit, and will ask the trial court to determine as per law without being influenced by any of the observations made by us. It may be 6%, it may be 10%, it may be 12%.
What I'm submitting is other aspects. From which date it has to be calculated, part may not be discussed by this whole process.
We are not, we need not disturb. That is clear in the earlier order.
6 months period has been set and
Yes,
it will be after 6 months only.
Now, what will be the 6 months on which date you have
Yes,
submitted?
that also has been determined.
Suppose you have submitted on the last day of the 6th month. Why 6 months will count from that date?
That day
Suppose they have filed. So this is a factual determination.
This order was
Otherwise, without affidavit, it will be difficult on our part. We will dispose it of with a liberty to you. And that is already clear in the earlier judgment. What more is more? That's there, that's all. We need not make any clarification.
My lord, I am appearing for respondent number 2.
Yes.
I am appearing for respondent number 2. In this case, we have nothing to say, my lord. Have
Nothing
say
to say.
respondent.
Mr. Singh responded. Yes.
Obliged, Lordship.
Oblige, Your Honor.
Item number 3.
For the LCR on last occasion.
Share received. The original record, lower courts records, has been received, full stop. Accordingly, registry to prepare a paper book, full stop. Yes, it says that additional public prosecutor has not furnished service report in respect of respondent number 2.
Lordship.
The learned additional public prosecutor submits that she may be granted
Lordship.
some time to obtain instruction from the jurisdictional police officer
Lordship.
as regards status of service upon respondent number 2.
Lordship.
Prayer is allowed. List of the 4 weeks.
Lordship. Obliged, Lordship.
What is this tell us?
Yes.
Short. If it will take us much time, that may not be possible today because we have a very long list, both of us today, 3 lists.
I have a limited prayer.
No, you have a limited prayer. Tell us how many persons are with evidences, witnesses are there.
Before going that, just send a brief for it.
Mm. Mm.
Today we are challenging the judgment and order record of 9/2022.
Mm.
In fact, in this case, what happened is that the plaintiff and the appellant was having a relationship since 2021.
31?
2021.
Okay.
21. And then they went staying together in the rented house. They are having a love and relationship for almost 1 year. And then even the girl also proposed for marriage, which considered.
How age was determined? It is under POCSO. Judgment first.
Delivery of judgment of item number 69.
The impugned decision of the screening committee based on principle rendered in NR Parmar is not sustainable in view of the determination made in K. Meghachandra. The respondents who were selected for promotion on the basis of limited departmental competitive exam cannot be termed as direct recruits in terms of the decision rendered by the Honorable Apex Court in case of Akhilesh Prasad versus Jharkhand Public Service Commission and others. Full stop. The respondent's promotion cannot be treated from the date of vacancy or from the date of vacancy, and their seniority should be determined on the actual date of entering into the cadre. Full stop. In view of the aforesaid, the determination made herein above, writ petitions are allowed by setting aside and quashing the decision of the impugned departmental screening committee meeting dated 11/6/2020 and the final seniority list dated 24/6/2020. The respondents are directed to prepare a final select list in terms of the determination made herein above. The department may also publish a draft selection list on the basis of determination made herein above to give opportunity to all members of the cadre. The entire exercise be carried out within a period of 2 months from the date of receipt of a certified copy of this order to be furnished by the petitioners. Now, there are some minor corrections, so you may get the copy today or maybe tomorrow. Okay.
Much obliged.
Keep it in the chamber. I'll keep the file in chamber.
Mayor, my lord.
Yes.
I would like to mention item number 20, my lord.
Item number?
20, my lord.
There are many lists. Which list? Oh, it's serial, na? Okay.
Yes, ma'am.
Item 20.
Yes, I have to file my reply, my lord. Maybe given some next time.
The learned counsel for the petitioner prays for and is granted
3 weeks time.
3 weeks time to file the
Reply.
reply affidavit.
Obliged.
Yes.
My lord, I beg to mention item number 24 to 26, 24, 25 and 26, my lord.
24,
24, 25 and
25
26.
and 26. Yes.
This is a promotional matter, my lord. This, I have already taken consent from the other party.
You are for the
also.
petitioner.
No, my lord.
Order?
What, my lord?
You are appearing for?
Appearing for the Tigaram. On
No,
behalf
no,
of petitioner.
respondent
Yes.
or
No, the petitioner.
petitioner.
Yes, in
What?
item number 25 and 26, we are the petitioner, but in item number 24, we are in the.
Now, what is your prayer? Tell us.
My lord, since this matter is taken by the department now, they are taking it under the consideration. So this matter may be list after 4 weeks, my lord.
Okay. On the prayer of the learned counsel for the parties, list this matter after 4 weeks.
My lordship,
Yes.
lordship, I beg to mention item number 27
Hmm.
on behalf of N father.
Hmm.
Kindly this matter may adjourn for today and this after 3 weeks.
Okay. On the prayer of the learned counsel for the petitioner, this matter stands adjourned and be listed after 4 weeks.
Lordship, interim was there. Kindly
Oh, then give a date, list this matter, adjourns and list this matter on, give a date after 4 weeks. Seventeenth of September 2024. Interim order pass earlier shall continue till then.
Chief, I beg to mention item number 22.
22. Yes.
Pleadings are not complete in this.
Huh?
Pleadings are not complete in this.
Whose pleadings is not come? You are for? Standing counsel, education. No, state respondent. The learned state council prays for and is granted 4 weeks time to complete his instruction and pleadings. Full stop.
Well, there's an interim order that may be continued.
List accordingly, interim order pass earlier shall continue till the next date of listing.
Much good.
Item number 10.
My lordship.
Yes.
Pass order for consent.
Timing.
I will just pass order.
Item number 11.
What is this? Yes.
My lord, the leading counsel is in video conference.
Huh?
In video conference. The leading counsel for a petitioner
Huh?
is in video conference.
Video
So, video,
conference.
yes.
Yes. Yes, who is appearing? No voice, no voice. We cannot do matters like this. Here is connectivity issue. Yes. Though the learned counsel for the petitioner has appeared through virtual mode, however, due to due to poor connectivity, this court is unable to hear him. Accordingly, matter stands adjourned and be listed after 3 weeks.
My lord, kindly fix it on 5th of September.
5th of September.
Yes.
Yes.
Highly obliged.
Yes.
I am for the caveator in this, my lord, in this case. Respondent.
This is
I am
not
for the
good. This is not good practice.
What to do, my lord?
Well,
What to
as far
do?
as
See
Mr.
the
My
net-
learned,
see
my,
the
my
net-
learned friend,
We are
My
not
learned
even
friend-
we are not even been able to see you properly, not to say about your voices.
I think I am very clearly audible.
You are clearly audible.
Yes.
I am not clearly audible.
Now. Yes, what is this? Tell us.
Well, it's a very simple case. Well, it's a transfer order.
Hmm.
Well, the petitioner before lordship is about to retire in 6 months' time.
Hmm.
Now he has been transferred out
Hmm.
on
Only sorry for disturbing.
By-
Only sorry,
by
delete
by
one.
under- even left
My
by
sorry,
process, my
my
lord.
learned
Mr. Das,
friend-
your voice, your video, everything is broken.
My lord. My lord, I have been transferred by undertaking a process which your lordship has the other day disapproved, and the matter was taken before the Honorable Supreme Court. Supreme Court has upheld the order passed by your lordship. My lord, what has happened in this case, my lord? Absolutely, there was no, your lordship may recall also by division bench, my lord. There was absolutely no proposal for my transfer. There was a request made by the local NMLA.
What happened to that case? That was appeal.
Yes, madam, that was taken to Honorable Supreme Court, and after 1 month or so, I have annexed the order passed by Honorable Supreme Court on 13/10/2023. The Honorable Supreme Court dismissed their SLP, madam. Now, I just want to take your lordship to the judgment passed by your lordship on the last occasion, which your lordship will find at page 63, madam. These are the grounds again, my lord.
Mr. Das and Mr. Das, how can you come over both of you?
When,
See,
my lord?
it's difficult. Motion matter. There is a prayer of say you are on caveated. We must give you a proper hearing.
Yes. That's of course, but
See, your voice is totally broken. Your videos are broken.
Perhaps my one is very clear.
Your one is clear.
Yes. I am actually not
Because
speaking where
he is in a public network. You are on a private network.
no, madam,
but
I'm at my chamber, madam, at home.
That's why you are on a
that's
private
the
network.
reason.
He's in a public network, and
Yes,
we know we
I-
know the network inside Guwahati High Court.
Absolutely correct. I'm in Guwahati.
Very
High Court,
bad.
So
Matter under process. It will be far better within months. But now to Mr. Das, it's difficult to hear you.
But- and this is I understand your lordship whole problem, but this is also very urgent matter. My learned friend may have, but
I
at
do
least
not
your
think it's
lordship-
urgent. I do not think it's urgent because both of you are from Guwahati.
But as far as I am concerned, I am keeping a little unwell, madam. Last time when I came, immediately after coming back from Itanagar, madam, I felt sick. That is why I have not traveled. Madam, issue is very simple. On the last occasion, your lordship allowed the writ appeal by interfering with the transfer order on 2 grounds. Your lordship clearly held that it is vitiated by malice in law because there was no proposal to transfer him out. And only because the MLA suggested, ultimately, abruptly an order was passed, which your lordship will find at page 63 of my writ appeal, my lord. I have annexed the order passed by your lordship. This time also, absolutely same. Lordship may kindly come to the RTI document that I have found out through RTI, my lord. Page 81 is the application. Page 82, lordship may just have a look. Page 82, my lord.
Same petitioner.
Same petitioner, my lord. And he has 6 months to retire only. My lord, somehow I feel that there is a ego that the judgment of the court we will circumvent this way or that way. And the proposal which I have annexed at page 82 by the local MLA for 3 persons, including the petitioner, the entire proposal has been approved by passing the transfer order. All 3 of them transferred to a place where the local MLA suggested. Absolute non-application of mind by the administration. There is no administrative exigency in the transfer order, only to satisfy the ego of the person, because earlier your lordship set aside on this ground. Absolutely, sir. Lordship, kindly have a look at page 82. I'll satisfy your lordship. Page 82 is the suggestion of the local MLA. Kindly, may I read, my lord? This is regarding transfer posting of C. Idak Angu, the private respondent here, presently posted as DD, the Deputy Director, Elementary Education, Itanagar, to the post of DDSE West Yang.
Where is the Supreme Court's order?
Supreme Court's order, lordship will find at page 71, my lord. It is dismissed in limine, my lord, page 71. My lordship's clear finding is that it is vitiated by malice in law because there was no proposal. This time also there was no proposal. I'll show the proposal. This time also again, my lord, proposal was in respect of others. Now abruptly, finally, the transfer order was issued. It was issued the way it was suggested by the MLA, which your lordship will find at page.
Mr. Das.
Yes. Are you lordship hearing this matter?
We are trying. Yes. Or you can
I'll
come
just-
on.
My lord, I'll just satisfy one thing before your lordship. Judgment passed by a division bench and dismissed by the Supreme Court in Imli, that doesn't mean it merged with your
No,
lordship.
it will
division
not
bench.
merge. There is no
Yes,
doubt.
that's number
There is
one.
no doubt.
There is no doubt.
No
There is
doubt.
no doubt. Second aspect of the matter, which my learned friend has argued, abruptly his name came, it is not. I will show it. Abruptly his name has not come up. If you see the
Mr. Das.
note, you will. My home.
Okay.
My
we
lord,
are-
come at
we are-
2
we are-
o'clock.
Just listen to me. Listen to me. When are you coming? Next. When
My
can
lord,
you come?
21st.
Till then, status quo.
Yes.
Otherwise, not possible. Hard.
My lord, can it
We
be
are
taken up at 2 o'clock?
not even issuing notice at the
No, can it be? Can be taken up at 2 o'clock? 2 o'clock. I'll go back home and I'll because your lordship is not hearing it.
Let it be on Monday.
But then
Monday.
no order should be passed. No,
Huh?
Monday it will be difficult. My
Monday.
21st, again I have to travel. Let it be on 21st. In the meantime, no order should be.
Nothing will happen till 21st. We'll
My
just
lord, my lord, will not pass an order of, please don't pass an order of status quo. Otherwise, your lordship will hear me.
No, my lord,
Don't pass a
otherwise-
status quo. Otherwise, your lordship will kindly see. I'll satisfy.
Okay, you are good.
satisfy your lordship.
You
Yes,
are
I'll
good.
satisfy your lordship. Yes,
You are good.
I'll satisfy your lordship. There is not a case of even a status quo interim order to be passed by this court. With great respect, I am telling.
Do
My
you
lord,
say
will
that?
kindly
Do you say that he is not retiring within 6 months?
No, that's maybe. He's retiring.
Okay.
Your lordship will
Are
recollect.
you not agreeing that he is the petitioner in the earlier read proceeding and
Why I will not agree? But
and
why I will not
we
agree?
do not know. We do not know. So therefore, we are having
That's what
the
I'm saying.
clarification. And is it not
Same
the
person,
same
same
place and
person.
same transfer? We need to examine this matter.
My lord, it is not a same transfer. That's the whole case.
Same,
He may be
in my
the same
case, my lord,
person. My learned friend will not speak. Please, I didn't disturb you. Please, Mr. Mozumdar,
Okay,
you know
are
very
good.
well. Please don't disturb me.
You are good.
See, number one, my lord, number one, maybe the same, that's the same person, read petition, but this is a different transfer order. So kindly see in a perspective of different transfer order, how it was passed. Because my whole case, my learned friend projected in paragraph 20 is abruptly his name has come up later on in note. Now it is not that case. Kindly see the note. Kindly see his note. That's the whole case. 2 points he has taken. Page 81. Kindly see page 81. Please see 81. That's an RTI he is relying on. RTI. Lordship has looked RTI. RTI,
Really?
that's page 81. Now,
82 document.
now kindly see at page 83. Kindly see page 83.
82 you are
See
ignoring.
page 83. My lord, you argue, Mr. Majumdar, nobody is stopping you. Nobody is stopping you. Please see 83. My lord, kindly see page 83. This is the first list. Transfer and posting of principal, that's a note number 15. May be seen at page so and so a prayer letter sent by several principal for transfer and posting, which may be seen below. Now, this is the list, which the first list, which they projected that this list, in this list, his name doesn't appear. The Dukan Kato's name doesn't appear. So abruptly, the list he relying is at page 94. 94, note number 44. Note number 44 is relying. Now my lord will kindly see again page 83. See page 83, my lord. See page 83, and now that is the first list. Now if you turn to page 85, please turn to 85 and see note number 19. Note number 19. Therefore, the file is resubmitted for direction, please. So that
Yes, yes.
list in the
We are
name.
not hearing you, no, not possible.
So let it be at 2 o'clock then, my lord. 2 o'clock.
No, no, not possible.
2 o'clock.
We'll fix it any other day, will give us the task.
21st, my lord.
21st. Not possible in this way.
That is why
Yes, where is
last
your
time
record?
yesterday, my lord,
Where is your
status quo,
record?
my lord, again he will take this advantage, my lord. Please do not pass any order, my lord. Let it remain. We'll see it on 21st, my
No,
lord.
if we can hear you properly, we may not pass an order. But prima facie, this court is satisfied, open to your argument of not granting a status quo. There is no doubt about that. This court will not take any view. But difficulty is that I have not been able to hear anything from you. We can
That
fix
is
it.
why.
We can fix it tomorrow, but network is same here. But I do not know why you can do it tomorrow.
My lord, let it be. What I'll do tomorrow, let it be fixed. No order should be passed. I'll do at my home. I leave all the matters do at home. Tomorrow.
Don't do anything.
Tomorrow. Let it tomorrow, my lord.
Tomorrow.
Till implement this order.
Tomorrow, my
My lord, till then status.
Till tomorrow, nothing. Tomorrow at the motion. Till tomorrow, nothing. Yes.
I'll do from my home, my lord. I'll do from.
You do it from tomorrow. See, Mr. Das, we are not been able
I'll
to
do from my home.
understand anything what you are saying.
No, what I'll do from tomorrow, let it be fixed on tomorrow, and I will do it from my home.
Tomorrow we will list it. And since this matter is adjourned tomorrow only for this technical things, we are maintaining a status quo till tomorrow. Okay.
Fine.
Please don't maintain. Please don't maintain. My lord, I'll just
Mr. Das, what
make
are you
a prayer.
saying?
Please don't.
You cannot argue properly.
I am
Your
not-
network is
I
not
can.
there.
It's not that.
Please
I-
leave it to this court. Leave it to this court. Cannot be.
My lord, it is not that I am not arguing properly. My lord, it is
No,
not
you are
that
arguing, but
the
network is not
connection.
permitting.
My lord, that's
No,
not
no.
my fault, my lord. Why your
No,
lordship
it's
is
not.
not?
It's not
I am
your
in the
fault.
High
But
Court.
what to do?
Then if I am in the High Court
that is-
premises, my lord. I'm in the High Court premises, my lord. It is not that it is my fault. For that, why my client, your lordship will reject it. That's I'm not saying. But at least your lordship will hear me.
You argue.
No,
We'll
tomorrow
decide.
your lordship.
We'll take a
No,
call right now.
tomorrow.
You argue. We'll
No,
take a
my lord,
call
your
right
lordship
now.
is
You
not
argue.
hearing me.
Please argue. We'll take a call on right now. Yes, argue.
No, your lordship is not hearing it. Your lordship is my voice is breaking.
So therefore,
So
we
at
are
least-
be reasonable. We are fixing it tomorrow. You are saying don't pass in status quo order.
No, then your lordship will pass an order. Your lordship will pass an order. What can I say, my lord? Your lordship will pass an order.
Yes, tomorrow. Don't do anything. We'll pass in status quo order.
Deeply organized status quo.
My lord, this is second approach for this honorable court.
What is this?
This is relating to payment of compensation in the acquisition of land, my lord. My lord, there was anomalies in the
Just
calculation.
write down. The learned decision application. Just wait for a minute.
All right.
Where is the matter? That earlier matter? Transfer. The Didas and Mozumdar. The present application is filed and challenging an transfer order dated 7/8/2024, by which the petitioner has been transferred from the post of Deputy Director of School Education, DDSC, Alo, to the post of Principal, Nehru Memorial Government Higher Secondary School, MMGHS, full stop. The grievance of the ground of challenge is that thereafter you writing, both the learned senior counsels, Mr. D. Mozumdar, appearing for the petitioner, and Mr. D. Das, appearing for the private respondents, are present virtually. However, the network connectivity of Mr. Das is not clear, and therefore this court could not properly hear his argument. Accordingly, the matter is listed tomorrow. Tomorrow as past item. Latest matter tomorrow. Full stop. Tomorrow. Considering the nature of grievance raised, more particularly on the ground that the petitioner is being transferred at the fag end of his career, that is, he is to retire. He is only having 6 months to retire, and that the present order is passed to bypass the earlier judgment of this court in writ appeal, earlier judgment of the division bench in writ appeal number 219/2023. 2023. This court is of the view that till then the impugn order dated 7/8/2024 shall not be given effect to.
This private respondent already joined.
No, we have stayed it. We have stayed it. Yes.
Now, while this present include order transfer, there's no station transfer. It is within the place only. Our town only.
We'll hear it everything tomorrow. Shall not be given effect to, and the status quo of the posting of the petitioner shall be maintained. Please do not play with the courts, huh? Yes, what is your question?
My lord, this is relating to payment of compensation in the acquisition of land in the construction of highway. My lord, my property was assessed for compensation for 1,42,29,044. But I was paid 1,15,88,540.
What is your issue notice?
Just a second. This is the second approach for this honorable court. Earlier, I have submitted 2 representations. I have stated all these things that
you want to disposal of the petition. Let us cut short.
Yes.
You want the disposal of the petition.
Yes, madam.
Cut short to that.
Yes.
Heard the learned counsel for the petitioner. The grievance of the petitioner is that while constructing the road from Nacho, from constructing the road, Talihatu Nacho, the property of the petitioner has been acquired. Full stop. It is the case of the petitioner that the respondent themselves assessed the compensation for such acquisition to be rupees 142,29044 within words, within bracket words. But Even after such assessment, comma, according to the petitioner, he was paid rupees 1,1588,548.
Correct.
That is an amount of rupees 26,40,496 is yet to be paid to the petitioner in terms of the assessment made by the respondent themselves. It is the case of the petitioner that he has filed representations before the authorities on
Two representations. have been
filed two representations before the authorities.
Yes,
What is those?
yes, madam.
That is important.
Yes, yes, madam.
You have not
One
annexed.
one is dated 8/3/22,
Dated 8/3/2022 and
another one is,
another dated
just a second. 5/2/16, 2000.
5/2/16.
Yes,
Long back. 5/2/2016. You give with the both the date 16 and 20.
just a second. No,
Full stop. However, to of no avail. Full stop. Accordingly, the learned counsel for the petitioner submits that the petitioner shall have no grievance if the at this stage, if the present writ petition is disposed of, directing the respondent authorities to consider his representation and pay the already assessed amount within a specific time period. Full stop. The learned state council has submitted that if a proper assessment is made, the state will not, if a representation is filed, the state will definitely consider such representation, however, in accordance with law. Full stop.
Under section 21, notice is given to them. That was not.
Okay. Anyway, we'll also, you give a reason so that that can be taken note of in a full stop. The full stop. In view of the aforesaid consensus, the present writ petition is disposed of, permitting the writ petitioner to file a fresh representation before the respondent number.
Deputy Commissioner.
Give the number. Respondent
Just a second. No. That is
before
wrong.
the concerned deputy commissioner.
Respondent number.
Concerned deputy commissioner.
Two.
And on the receipt of such representation filed by the petitioner, let the competent authority, that is the deputy commissioner, consider the grievance of the petitioner and pass the region order in this regard. Full stop. Such exercise be completed within a period of 3 weeks.
4 weeks.
4 weeks. Within a period of 4 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner before the concerned deputy commissioner. That is along with the president. Disposed of. Yes, what is this?
Lordship, Lordship, this writ petition challenges the disqualification order passed by respondent number 2, who is the Panchayat disqualification order.
Disqualification from what?
Panchayat, Lordship, passed by the respondent number 2, Lordship.
Who is respondent number 2?
The DC order, East Coming District, Lordship.
Okay, we'll issue a notice.
Lordship, we have a prayer for interim, Lordship.
Disqualification is difficult to say. What is the ground of disqualification?
Actually, Lordship, the grounds for disqualification have not been discussed in the impugned order. But basing from the complaint, that
Who issued the complaint?
the complaint was issued by the Mandal President. He is respondent number 3 here in Lordship. Lordship will find the complaint at the type copy of the complaint is 34, page number 34. Lordship, if the complaint is perused, what they are saying is that I have acted in an anti-party, engaged in an anti-party activity because I have not voted for the official BJP candidate. And the impugned order that is passed by the respondent 2 has not discussed anything or the evidence. Now, Lordship, it is...
This relates to who, where?
East Coming District, Lordship. District, Lordship. Now, Lordship, our submission is that, Lordship, voting, Lordship, if done in secret, Lordship, there will be no evidence how they will prove that...
Was there any whip? Was there any whip?
Lordship, we There was a
Now,
whip.
what is the provision under the act? Tell us.
Lordship, the provision is
The
under
grounds of
section 3.
disqualification.
Section 3. Lordship, section 3 provides for two scenarios wherein the disqualification can be incurred, Lordship. First, if I give up the membership of the party. Second, if I act in contravention of any direction by the
Well,
party.
give out a provision. Give out a
Section
provision.
3, Lordship.
Section 3.
Section 3. More particularly, section 3(1)(b, Lordship. Because I have not given up the membership of the party, Lordship.
Now, where is the direction of to vote? That's why I'm asking, where is the whip? Because
Lordship,
there is you have been disqualified under clause B of subsection 1 of section 3.
yes, Lordship.
Is that it?
Yes, Lordship.
Now, is
The-
there any direction that you should vote?
No, Lordship, the whip we have not been able to procure, Lordship,
But
but
there
the
was a
complaint is
whip.
there.
There was a whip.
There was a whip and
If
there was.
there was a whip, then
Lordship.
how can you say that this is illegal? Because it says if he votes,
Yes, Lordship.
contrary to any direction issued by the political party to which he belongs.
Yes, Lordship.
You accept that
No, we did not accept. In fact, in the reply to the show cause notice, we have categorically stated that we have not acted in contravention of anything.
No,
Anyway.
do you disagree that you are not a member, you are not elected on BJP ticket?
We accept, Lordship.
You accept,
Yes,
you
Lordship.
have elected on a BJP ticket.
Yes, Lordship.
Now, the law prescribes that if you vote
Yes, Lordship.
against a direction issued by the political party to which you belong,
Yes, Lordship.
there is a whip, that
Yes,
whip is the direction.
Yes, Lordship.
So there is a direction to vote in favor of the BJP candidate.
Yes, Lord.
Allegation is that you did not vote.
We did not vote against in fact, we vote for the BJP candidate.
Now, how it is to be determined? Where is the so-called reply?
The show cause reply is at page number, Lordship, 39.
30?
Annexure 39, page number 39. Herein, we have categorically stated that we have been participating for the activities of the party and we have not engaged in any anti-party. And in fact, we have campaigned for the official candidate. Now, Lordship, our ground for challenge against the disqualification order is that the respondent number 2, the DC, he did not discuss anything that how he came into the conclusion that we had engaged in anti-party activity. Now, Lordship, this is a general election they are talking about for MP and MLA, Lordship. Now the voting is done in secret, Lordship. It is impossible to say that we have not voted for them, Lordship.
Where is the complaint against you?
The complaint is the type copy is page number 34, Lordship.
30?
34. Page number, the type copy, Lordship. The para 2, Lordship, they have made a specific.
What is the procedure laid down?
Pardon, Lordship. Under the Act, Lordship.
In the act.
Under the Act, Lordship, the member secretary will make the complaint is made to the member secretary by the party. The member secretary forwards it to the DC and the deputy commissioner.
Where do you get that?
Section 6, Lordship, of the Act, Lordship. Lordship, before it was the state commission, but in a subsequent amendment, it has been amended to the deputy
Now,
commissioner.
where is the complaint made to the member secretary? Page
The-
34.
Yes, page 34 is the member secretary Panchayati Raj, Lordship, dated 2nd of May, 2024. Accordingly, this complaint was forwarded to the DC and the DC has passed the impugn order, Lordship, 29 July 2024, Lordship. Because, Lordship, even in the final order, wherein the final hearing was done,
Don't go so fast. Don't go so fast. Let us understand the procedure. Then also we can say that whether procedure is followed or not. We cannot interfere with the decision,
Lordship.
but the decision-making process.
Mm.
whether it was followed. Now, so section 6.1 say what? A complaint that a member has become subject to disqualification under section 3 may be made by a member or political to the member secretary of the concerned authority. Your disqualification under 3B, is that it?
Yes, Lordship. And Lordship, they have said that in the show of notice, in the impugn order, and hearing was conducted, Lordship, a final hearing, but we were not given any copies. We were not given any notice for appearance. And in the order, it is reflected that only the respondent number 3 and the party members came and they put up their case before the respondent number 2.
Now, after receipt of DC, what the DC will do?
The DC will issue a show cause notice, Lordship.
Where is that?
The show cause notice, Lordship, is at page number.
No, where
And
is the provision that DC will issue a show cause notice?
There, per se, I believe it is read into subsection 2, Lordship, of 6, Lordship.
So, yes,
Who
where
shall
a
decide?
complaint under is received by the member secretary
Yes.
of the concerned locality, he shall within 24 hours from the receipt refer the same decision to the State Election Commission.
Lordship, that has been amended subsequently. I provided the copy, Lordship. It's Deputy Commissioner.
It was to the Deputy Commissioner,
Deputy
who
Commissioner.
shall decide the question within 30 days on receipt and decision shall be final.
Yes, Lordship. So now, after forwarding of the complaint, Lordship, we were given the show cause notice, Lordship.
Where is that show cause notice?
The show cause notice is at page number 37, Lordship, annexure 3. Lordship,
Then,
so after
where
the
is the impugn order?
impugn order is annexure, Lordship, 5.
But you have not
43.
taken a specific stand that you have not voted.
We have taken specific stand.
Where is that?
Lordship, in our reply, show
That's
cause
what
notice 39, Lordship, annexure 4.
Where is the statement? That we have not voted for the others but voted for BJP. You have said you have not disobeyed any order.
Lordship, it is also to inform your authority that in the recent assembly parliament, we have party in favor of the BJP candidate of our
No,
concern.
that is an election.
Yes, Lordship.
What is the allegation? That you have voted
In the general assembly,
in
Lordship.
general assembly.
Assembly.
That is
Against,
for disqualification.
yes, Lordship. So that is what I'm saying, Lordship. How
Or-
can
We thought that there was a no confidence
no, Lordship.
vote. You have voted against your elected candidate. Where is the order?
Order is annexure 5, Lordship, page number 43.
Anything can happen here, na? Anything can happen. Yes, where is the order?
Oh, page 43, Lordship, annexure 5, Lordship.
Page 43. Hard. Mr.
Jitalo, Lordship.
Chitaro, learned counsel for the petitioners. The petitioners, how many
20, Lordship.
petitioners? 20 in numbers has approached this court assailing an order dated 29/7/2024 passed by the Deputy Commissioner, SEPA, East Kameng District, Arunachal Pradesh, whereby the petitioners will disqualified as Panchayat members under section 3 within bracket 1 within bracket B of the Arunachal Pradesh Local Authorities Prohibition within bracket Prohibition of Defection Act 2003. First up, alleging that in the last in the last assembly elections, the petitioners who are members of Bharatiya Janata Party, elected members of Bharatiya Janata Party of what Gaon Panchayat?
Lordship. 11 Sepa West Assembly Constituency, Lordship.
No, you are member of what? Some Gaon Panchayat, Anchalik
Yes,
Panchayat?
Lordship. We are from different Gram Panchayat,
Ah.
Lordship.
Who are elected members of different elected members of president.
Pardon, Lordship.
You are members or president of Gaon Panchayat.
Some are members, few are chairman also,
Ah.
chairperson also.
Petitioners who are members / president / chairman of different Gaon Panchayat committees under
11 Sepa West Assembly Constituency.
Lemon Sepa West Assembly Constituency. How I started the line? The petitioners who are so and so had voted against the official BJP candidate. On the basis of such complaint before the member secretary, the deputy commissioner initiated a proceeding of disqualification under section 3(1) within bracket B of the Act 2003 and issued a show cause notice to the petitioners. Full stop. The petitioners replied to the said notices, taking a stand that they have not done anything detrimental to their party and they had actively participated in support of the official BJP candidate in the assembly election. Full stop. Thereafter, the deputy commissioner, by impugn order dated 29/7/2024, had disqualified the petitioners as recorded herein above. Full stop. The basic ground of challenge is that the deputy commissioner has not recorded any reason how the deputy commissioner had arrived at such a satisfaction of the petitioner being disqualified under section 3(1) B of the Act 2003, nor any opportunity of hearing was given to the petitioner to substantiate their case except allowing them to file a show cause reply. Full stop. This matter needs further consideration, more particularly in the given facts that petitioner has duly replied and there is no specific reason of the deputy commissioner in rejecting such contention. Full stop. Accordingly, considering the matter in entirety, let a notice be issued, returnable on given date after 4 weeks. 3 weeks, after 3 weeks. Because private parties are there, therefore 4 weeks. Otherwise, service also cannot be deemed. Main, but the private respondents are 4 weeks. Give a date after 4 weeks. 12th of September 2024. Full stop. Having regard to the facts and circumstances as recorded herein above, it is provided that till the returnable date, the impugned disqualification order dated 29/7/2024 shall remain suspended. Full stop. The respondent shall be at liberty to file application for modification, vacation of the interim. Steps within 3 days, huh? In addition, permissions dusty to be routed through the registry. Okay. Upon the private respondents, BJP is a party. Private respondents. Okay. Yes. Yes. Where is Mr. Tara? He was here. Yes.
He is in court number 2, but this matter is not taken up by my senior university, Tara.
Okay, who will appear in this? None appears for a petitioner on call, list after 3 weeks. Yes.
This is contempt.
Yes, what is this contempt?
Your Honor, here I need to take some instruction from my client as they have not fully complied, Your Honor. So some
Learned
instruction
counsel for the petitioner submits that though the respondent has taken a stand that they have complied with the order. However, he needs some instruction. Where is the order? Page? WBC 280?
Yes, sir.
Where is the final part? Fallacium in interest.
This is considered by the state respondent
Hmm.
and then forwarded to the.
Okay, since he is wanting an insert, what we have written, did it detected, Muni? Do have they taken? No, just slide one. Delete all this. The learned counsel for the petitioner press for 2 weeks time to obtain complete instruction whether the order has already been complied with. Full stop. Prayer is allowed. List this matter after 3 weeks. Obliged, Lords.
Wait, please, your lordship. Lordship, this is a compensation matter, lordship.
Huh?
Now, respondent number 1 to 5 are not yet filed their counter affidavit, lordship.
Who not file affidavit? Respondent number 1.
1 to 5, lordship.
1 to 5. Yet 10 to 10, 11, 10 to 11 filed.
6 to 11 filed,
6 to 11 filed. Yes, main is the state.
Lordship, kindly, I may be allowed to file a rejoinder, lordship.
You have to file rejoinder
Yes, lordship.
to the affidavits filed by 1 to 10, 6 to 11.
6 to 11.
Okay, learned counsel for the petitioner press for and is granted 3 weeks time to file reply affidavit to the affidavit in opposition filed by the respondent number 6 to 11. Full stop. In the meantime, the state respondents may file their affidavit in opposition. If so advised, comma, if so advised.
Number 18.
May I, Lordship?
Yes.
Lordship, I'm here for the petitioner. I filed my additional wakalat number in respect to.
I'm not getting it.
I filed my additional wakalat number, Lordship.
We have heard additional affidavit, but not additional wakalat number.
Lordship, previously now I'm also been engaged by the petitioner, so I'm filing additional also with along with the previous advocate counsel. That's what I'm.
You were engaged originally.
No, Your Honor.
You have recently.
Yes,
So
Lordship.
you say that no additional. Addition mean you have already filed. There is an addition. Isn't it?
Yes, Lordship.
When additional affidavit is filed, there is already an affidavit. You want to have an additional affidavit. If you are having an already wakalatnama, you want to file an additional. That is different thing. The learned counsel, Mr. You are Mr.
V. Jamo, Lordship.
Learned counsel submits that he has recently been engaged by the petitioner and accordingly he had filed his wakalatnama. This is your case?
Yes, Lordship. And
Now-
Lordship, we have filed an affidavit in regarding to this, an additional affidavit in regarding to our petition, and which you have submitted it to, have been received by the respondent this morning, Lord.
Huh?
This code is one additional.
Okay. Full stop. Not necessary. First
Mm.
part is not necessary. Delete it. The learned counsel for the state respondent submits that an additional affidavit has been filed by the petitioners today morning only. Therefore,
They might have filed that, but.
the affidavit, okay, then write it down. The learned state counsel submits that the copy of the additional affidavit filed by the petitioner has been served upon the state respondents today only. And therefore, he needs an adjournment to obtain instruction from his client and to file a reply if so advised. Accordingly, matters gets adjourned and be listed after 2 weeks.
Lordship, there is an urgency in this matter, so endeavor may be made to.
We do not think there is an urgency. If you have filed an additional affidavit long back and serve a copy today, we do not think we have urgency.
That is, Lordship, we had
It
filed
is
it
not-
long
it
way
is
back.
not correct.
Lordship, we have filed it long way back, but because of the court municip has given to them in the morning itself, that is the.
Anyway, after 2 weeks, we are giving, let them file an affidavit. You want a date?
No, Lordship. After
You want a fixed date?
No, Lordship, on 2 weeks.
Yes.
Obliged, Lordship.
Timing is difficult. What is this? Affidavit opposition 1 and 2.
Already filed, my lord.
Huh?
They have already filed, my lord.
File.
My lord.
And
Also,
what is
I'm sorry, my lord. 2, 3, 3 and 4, my lord. have
1
already
and 2
filed.
not filed.
1 and 2, my lord, may not be required because they are also.
Okay, timing, if timing, okay.
my lord, there is urgency in the matter, my lord. My lord, my simple case is allotment was
Okay.
given.
Yes, whose senior is not there?
My lord, respondent number 4, my lord.
Huh?
Respondent number 4, department, power department.
Lands belong, according to the respondent, land belongs to power department.
My lord,
And there was an earlier verification.
my lord,
On the basis of verification, there is an order.
My
It
lord.
went to appeal.
my lord,
Now, at the appellate stage, there was a settlement.
my lord,
Then again cancellation.
my lord. Price allotment, my lord, initially the complaint was, my lord, heard,
Yes,
decided.
yes, when can your senior come? Okay, after some time, let
My-
us see.
21.
21 has adjourned, isn't it? Yes, Anju. Yes.
Madam, I need some more time.
What is the issue here?
It's a transfer matter.
There is a stay.
Status quo
Then
is there.
status quo, enjoy your status quo. The Learned Standing Council for the Education Department prays for further 2 weeks time to complete his instruction and file affidavit. The stop prayer is allowed. This matter after 2 weeks. In the meantime, interim order passed earlier shall continue.
Obliged.
Item number 23.
May I lordship?
Yes.
Lordship, respondent number 1 to 4 are not yet filed the counter affidavit, lordship.
1 to
4, lordship.
Agriculture Department. Yes. How much time? 3 weeks time. Learned Standing Council for the Agriculture Department prays for and is granted 3 weeks time or 4 weeks? 3 weeks time to complete his instruction and file affidavit. First up, list accordingly. Any interim order? No. Is there any interim order?
I'll just give the intro.
No, no.
There's no interim order. Sorry. Obliged, lordship.
Item number 1.
Item number 1. What is 1?
May Lordship. Lordship, I am for the petition, Lordships. Lordship, early in the morning, Lordships, the Standing Council, Lordship, Rajiv Gandhi University, Lordships, informed me that he is some personal difficulties today, Lordship.
Uh,
So, Lordship, this matter may be fixed, Lordship, on 19, Lordship.
okay. As agreed to by the Learned Council for the parties, this matter on
19, Lordship.
19th.
Much obliged.
Why so many lists? They could
May I
have given-
plead?
Yes.
Your lordship. Well, item number, this was matter was last, listed last time. The lawyer's name was not reflected, especially we have taken steps and
Respondent number 7,
yes, now the Subbu Tapin is appearing on behalf of respondent number 7.
name is reflected.
Yes, my lord. And, Respondent number 6, we have taken dusty service and then we have filed affidavit of service. Respondent number 5, we may be given we may be allowed to file to serve dusty to the respondent number 5. Member secretary.
Okay, learned counsel for the petitioner. Praise for and is granted. How much time?
1 week, madam.
Learned counsel for the petitioner, just write it like that. Learned counsel for the petitioner is permitted to take steps through dusty upon respondent number 5. Full stop. However, such service be routed through the registry of this court. Full stop. And thereafter, the petitioner to file a affidavit in proof of such service. Full stop. Please this matter after 4 weeks.
3 weeks, madam.
No, service.
Okay, obliged.
That's why 4 weeks is a safer.
Service, madam. Obliged.
28 and 29. Non-express for a petitioner on call, list after 3 weeks.
Item number 13.
Yes,
Notice upon the private respondents are awaited, my lord.
service in respect of await service report in respect of respondent numbers.
Respondent number, my lord, 4 and 5.
Respondent number 4 and 5 and list after 3 weeks.
My lord. Obliged.
1.
Yes,
My lord, I'm for the petitioner.
you are for the petitioner, we know.
Yes.
Then tell us why this matter is listed. Service is complete.
Yes, ma'am.
Who is for the private respondent?
Private respondent K lawyer and
Okay.
3 to 10 is private respondent. The service has been completed. They have to file some affidavit.
Now what to be done today? Run that counsel for the respondent number 1 and 2.
Name is not.
Praise for and is granted. How much time? Tell us. 3 weeks time to file affidavit in opposition. List accordingly.
Item 32.
Now a place for the petitioner on call. List after 2 weeks.
Item number 33.
Same order. 2 weeks. You are on item number 33. Non-appears for the petitioner on call.
Lordship, in this case, I'm told that the petitioner has been.
But in subsequent recruitment, madam, she has been appointed.
That is probably why they are not attending this.
So let
matter
us
for
do one thing. None appears for the petitioner on call. Item number
33.
33. None appears for the petitioner on call. Though MSN Dungan and Mr. Swenso, learned counsel representing the represents are present. Mr. Swenso, learned standing counsel. For the department.
It appears the council has also withdrawn.
Let us
Petitioner
state,
counsel.
submit that the petitioner has in the meantime selected, and that may be the reason why the petitioner is not being represented. Full stop. Be that as it may, comma, as none appears for the petitioner on call, this writ petition stands dismissed for non-prosecution. At least you will have a chance to come back.
All right.
That's it.
Item number 34.
Yes,
Lordship, respondent, Lordship, my senior and the standing,
then it will go next,
yeah,
the
next week, Lordship.
Then it will go next week.
Yes, Lordship.
As agreed to by the learned counsel for the parties, list is method next week.
Interim order is there.
Interim order, pass earlier and shall continue till until further orders.
Yes, Mashallah.
Tell us, what is this?
My lord,
Very longish matter or
Yeah,
short?
very long, my lord. Otherwise, my lord, I just highlight the facts, my lord.
No, understand. If we go, we'll decide.
Yes, my lord. Otherwise, my lord,
It's, if it is long, there may be difficulty. We have 4, 5 CAVs.
Also, we have challenge a selection process.
Selection to which year?
in the year 2018, my lord.
Huh?
2018.
2018. What is the present status?
Present status is that, my lord, the private respondent, they have been appointed and now they are,
What is the post?
post is LDC, my lord.
LDC.
LDC.
It's a direct recruitment or promotion or
No, it was direct.
through
recruitment.
advertisement.
Yes, my lord.
What are your grounds?
My only ground is that, my lord, after the interview was conducted, I was very much sure that since I have performed very well, I will be selected. But what happened, my lord, when the result came out, I was not selected. I was put in this waiting list. So therefore, I have applied through RTI. I had to for many battle, my lord. Through first PIO of the Deputy Commissioner, I had applied through this RTI to furnish me the answer to all the respondents. But they did not furnish it to me. Then I filed this RTI in the appellate court.
Ultimately, you got it.
Yeah, ultimately, he did not even he too did not furnish me the copy. So I had to move this state commission.
Anyway,
So
you
from
got
state
it.
commission, yes, my lord, I was furnished.
Now, what did you get
Now-
from your report?
Now, from the information furnished to me, my lord, the answer script, I have cross-checked the answer script of the private respondent and myself. While cross-checking the answer script, my lord, in fact, my lord, the answer key provided by the board, that was also not correct. Since I have not challenged the answer script, I will not be dwelling on that, my lord. But while cross-checking the answer given by both the private respondent and the petitioner, I have not been awarded 4 marks. In fact, in 2 questions for which I have given the same answer as they had given.
Okay.
So they were given the answer for that, mark for that answer.
Suppose we
But,
add these 4 months, then
Yes. Then I march ahead with 1.5 mark with this private respondent number 3. So that is my actual case here, my lord. Now, this is only I am summarizing, my lord. This is my case. So I have processed and it has been found that
so
even-
according to you, at the end of the day, 2 questions, 4 marks each is
2 mark each, my lord.
2 marks each, total 4 marks
Yes.
where wrongly you have been deprived.
Deprived, my lord.
Because the same mark is given to the private respondents who
No.
were immediately above you.
Yes, my lord.
Okay, so immediately above you.
Yes.
Supposing that mark is deleted from them also or added to you, you will be placed above them.
No, my lord. My case is that they have been awarded mark for those 2 questions, but I was deprived of those
So,
marks.
therefore,
If these 4 marks is added to my total score,
Therefore, then you will go above them.
yes, my lord.
So therefore, suppose case is that, suppose you have wrongly been deprived, then also 4 marks.
Yes, my-
Either that can be added to you 4 marks or that can be deleted from them. Since you have not been, see 2 options.
Yes, my lord. Yes, my lord.
One
My lord
is
is correct,
that
my lord.
if that is a correct, then give correct.
Yes, my lord.
Then your decision was correct, then don't give them. So either way, you get
I
a
march
high-
ahead, my lord.
marks ahead.
Yes, my lord.
And therefore, you should enter and first come, last goes.
Yes, my lord.
One will go, not the boat.
Not both, my lord.
One will go.
Not both, my
Who
lord.
is that fellow?
Lordship.
Okay, we understand. What is your
Lordship,
case?
As per my because
Do you
of
dispute that
because
do you dispute this contention?
dispute very much because
How
I
you
have
dispute it?
to that to that only I have filed affidavit, additional affidavits.
Hmm.
Showing the his mark, her mark, which he have said he have done it right. We have, it is in the record, it's wrong, Lordship. My
Rejoinder affidavit.
rejoinder affidavit, yes, Lordship.
What is your stand in rejoinder affidavit?
Lordship, in my rejoinder affidavit, Lordship,
What you have any answer sheet?
yes. Lordship, the page I'll show you.
So accordingly, this is the
Lordship, page 20, my rejoinder affidavit, page 20, her answer. Lordship. In
page
the-
20. Yes, where is that?
And then, Lordship, before that, I'll show you the key answer notes, Lordship.
No, no, this answers, this is the page 4 is, what is page 4?
Page 4, annexure 1. This is answer sheet, Lordship.
Answer sheet of whom?
For GK, Lordship. This computer.
This is answer
application.
key,
Answer key, yes.
not answer sheet.
Not answer sheet, sorry.
But it is written as answer sheet.
This is answer key, Lordship.
This should be the answer key.
Yes, Lordship.
So
This
it was
is-
it was an OMR.
Yes, this.
It
for-
was OMR based.
Yes, ma'am.
OMR.
Yes, ma'am.
Yes.
So this is the answer key.
Yes.
In terms of this answer key, who is correct? He or the others?
Not
Number 2.
Huh?
Two is correct. It was the answer key. Lordship will see here, answer 13.
We
and
cannot sit over the, even if it is incorrect, we cannot sit over the,
That is true, madam.
that by the expert who says that sun rises in the, until and unless it is a
Yes, Lord.
situation that sun rises in the west.
I'll try to
What can
satisfy
I
your
go
lordship.
beyond, Lordship?
Let him
Answer
submit,
key.
my lord.
Lordship.
My lord,
This
let
is,
us have a hearing. Let him make submission.
No, this is, we are having overview. Because if issue boils down to the effect that whether against this question number so and so is wrongly given either to you or wrongly rejected to him. This is the issue.
This is
Yes.
If you say this is the issue, then we are proceeding.
Yes.
This is the issue, my lord.
Okay.
This is the issue.
So therefore, to rely on this issue, we will go by the
Answer.
decision taken by the answer key.
Yes.
Now,
Lordship.
according to you, in terms of answer key, who is correct? Don't say that answer key is wrong.
No, my,
Yes.
we will say that, my lord.
Okay.
We will say that, my lord. I'll just, then, my lord, let us come to my.
Let
case.
us see that questions first.
Let me show, sir.
Yes, my lord.
Lordship.
Let us see that question first. See, certain cases
I have
issue
made
are
a-
limited, facts
Not-
may be
not
very
my lord.
huge. If it is a case of dismissal,
Lordship, in my.
if it is a case of dismissal after 5 minutes, then we'll adjourn it. Okay?
My lord.
And if it is a case to allow, then we'll hear you. Okay, tell us.
My lord.
Just let us first
Yes,
see.
yes, my
I
lord.
will hear you, give you a patient hearing, but let me understand.
Yes, my lord.
Which are those questions? Question number?
Question number, my lord. Question number 34, my lord, I have made it, it's noting, my lord. Since there is so many noting, my lord, water. 34, sir, my lord. Question number 30. Yes, it is there. Now, my lord,
According to you, in which question they are given number, but you have not been tell us.
yes, my lord.
Let us first see the this.
एक मेरा noting करना है यहाँ
Let us first see the question.
Yes, my lord. Now, question is, my lord.
Question number. Tell us the number.
Question number is
12.
no, my lord. First, English. Question number 36, my lord.
English question number 36.
36, my lord.
Where do you get that?
This, my lord, will find at page number 40.
Is it in your affidavit? Additional affidavit?
Lordship, additional, earlier, he was binging on this computer application. The court directed me to file.
No,
this.
no, that we are not on filing. We are saying that additional affidavit you have filed
For
is,
this
is,
one only.
is the question paper a part of this? Answer. Where we get the English question number? English?
Yes, my
No.
lord. Yes, my lord.
We'll see then from that
This
only.
is for
My lord,
computer
may kindly
application
take up
only.
my repetition, my lord.
Okay, read.
At page number 40, my lord,
Page number
40,
40.
40.
Yes.
My lord, this is the answer script in English of the petitioner, my lord. And my lord, the
Page 40. Page just a minute. Go slow, go slow.
Yes.
Page 40.
40, my lord.
Okay.
This is the English answer is
Question number?
petitioner.
Question number?
Question number 36, my lord, at page number
Page?
52.
Question number 36.
Yes, at
Page?
page number 52.
Page number 52.
Uh,
Okay. Who is called the Napoleon of ancient India? Okay, list this matter after a week. You are not prepared. To argue before this court, you must be noted.
My lord,
We are
Come
clear.
prepared. See,
Sir, we are
I'm
clear.
very sorry, my lord.
you be prepared with where is the question paper. According to you, what should be the answer? According to you, what their answer is, and thereafter we'll go to the answer.
Yes, my
That's
lord.
all.
In fact, I have made a note of it, my lord.
But you have not, it is not here. Okay, list this matter on 19th.
my lord, can
Yes,
we make
yes,
a
ma'am.
shortcut? I had Supreme Court judgment.
Oh, judgment will come.
Regarding maintainability.
You are going to maintainability. There are hundreds of judgments. When it said that its matter is rule is already issued, that shows you have some weakness. The rule is issued. Court should not go to the maintainability issue. When already rule issued, admission is matter is for hearing. Where will you send him? Okay. On the prayer of the learned counsel for the petitioner, list this matter on 19th. 19th. Give a date as per your convenience. All's convenience.
Nothing accessible है था.
सितंबर में चला जाता.
19 is okay for me, my lord.
September.
In fact, my lord, I am very sorry, my lord. As my lord is observed, I have not come prepared. Because
No, you are otherwise you are prepared. Today might be you have some problem, difficulty, manner. You are not saying.
Otherwise,
Don't take it to be a comment on your preparation. Don't say, just it's a casual thing. Don't take it that way.
my lord, since the matter is pending since 2018, my lord, I want to get it disposed
At the earliest.
Yes,
We know that.
at
Your
the
anxiety we know.
on-
Either he
on
gets it,
19, my lord.
either he gets it or he goes out. Give a date.
Yes, on 19, my lord.
19th.
19 August.
September first, because is
Give a consensus there. I have no problem.
September.
September 10th.
September 10th. September 10th. Just you have a note. Where is the pages?
Yes, it
Where
was-
you have your note, but you have
Yes,
somehow a
I have
misplaced it.
displaced somewhere. my
Yes.
lord. This morning might be in the table. my lord.
Yes. Okay.
September 4.
How many lists are there? 3, 4.
May I please, my lord? My lord, learned counsel for a prisoner, Mr. Deepak, in his legs in court number 2, my lord.
Then after next week.
Can it be taken on tomorrow, my lord?
Tomorrow not possible. Matters we have already fixed. Tomorrow not possible. Make it next week any date or date after 2 weeks.
Otherwise, on my 16.
16th. Not 16th. List this matter. On after 2 weeks with a liberty to petitioner to make a mention
Yes.
for early hearing, for early listing. Yes.
Obliged.
Yes. Longest or shortest?
My lord, this is. My lord, we can continue with this proceeding, my lord. I'll place my argument by the my lord, since they have already filed affidavit, my lord.
Oh, that may not be appropriate. What is this?
This is, my lord, in the DPC, my lord, despite me being the senior, my lord, petitioner being the senior, he was not selected, my lord.
What is the
Petition,
principle?
Mr. Kedwell level.
Principle is that seniority has to be this.
What is his status?
Status is that now in the year 2013, all those private respondent number 6 to 11.
What is the entry of your selection?
They are just casual laborers, they are just appointed.
Let me
Not-
submit or else my lord.
No,
let-
come, just
let me
questions.
submit.
What are the,
I'll have that
what is
mass
the,
of patient, my
what is the procedure of regulation of this case? Do you have any state policy as regards that regulation?
In this case, Lordship, AG was also asked to deliver the.
It will be very important. See, there may be two things. One, you may say, okay, these are casuals. In terms of Uma
Yes,
Devi,
yes.
we are not regularizing. This is one way of looking at this.
Yes.
Other way is that you cannot be said to take a stand in respect of one and another stand in respect of others. That will itself create a discrimination.
Yes, sir.
Third issue is, if there was a selection, there is a vacant post, you are required. Subsequent to Uma Devi, there are different decisions where regulation has been granted. So I think this matter and many other matters, AG's presence is required in these cases.
Lordship,
When will be AG present? See, you cannot pick and choose. If your policy is this, then it is this. Okay. And if your policy you want to say that no,
it must be in record, Lordship. AG was present here and his presence has been dispatched already. It should be in the record.
My lord, yes.
It should be in the
His
record.
presence has been dispensed, my lord. Earlier he was.
okay, dispense, okay. Now, what is your stand?
Lordship, what we have said is, Lordship, the
So
particular-
that was the issue, whether you can do this. What is your policy?
Lordship, policy herein is basically, Lordship, merit come seniority is there.
Or any
Lordship, since
written,
they are
any
workers,
written policy
Lordship,
of regulation?
follow CPWD child establishment manual. This. Lordship. And Lordship,
What
while-
is the prescription there in? If it is seniority, if he is senior, you will be entitled. If you cannot, if you use a policy, it should not hit by the violation of Article 14. There must be equality, Article 14 and 16.
Yes,
Equality.
Lordship. Yes, Lordship. Lordship, which the
Who is your
department see
senior?
the thread also, Lordship.
19th.
19, my lord.
19.
Otherwise, my lord, I had some judgment, my lord.
Take.
Since they have not annexed any policy.
You are having a appropriate bench for this on 19th.
Much about.
This is the issue generally in Nagaland, and there are many judgments
Yes, my
there.
lord. There are so many judgments of our this Guwahati High
High
Court
Court.
also in this regard, my lord. Otherwise, since they are no saying nothing, this guidelines is guiding us. So
You must have a guiding principle. If guiding principle is A, you will have to follow the A. And in terms of guiding principle, if he gets, he gets. Or court may even go to that extent that you cannot do in violation of Uma Devi in anybody.
if they do not have
There
any
is an observation in this. So this matter needs some proper deliberation on 19th.
Lordship,
As agreed to by the learned counsel for the parties, this matter on 19th. This month. Some urgency is
Yes,
there.
sir.
They will have a senior bench there on 19th. Yes. Next. Okay. Yes, senior. Next 19th.
Well,
Too many pending was chamber. Where is the other side? Not yet complete. Who is the other person?
This is a very small case, Lord.
Ah,
Item number 10.
what is the issue
This,
here?
this is a land matter, Lord. First of all, in this land matter, the petitioner has applied a plot of land over which he has constructed some building. And over which, during the pendency of that application, one so-called notice has been issued saying that you explain the matter, why you have constructed the buildings. So, Lordship, I have on that day, Lordship, particularly on that day, I was.
No, there is a notice under the act.
Yes.
Now, why don't you reply to that act?
Lordship,
See, if you file a,
yes.
if you file a reply, a determination can be made.
That is,
Then there is a provision of appeal.
that is there, Lordship.
If that is there, why should we attach
Actually,
a writ petition?
this case is, there is two set of, I think, to my understanding, two sets of issue. One is, this application to be considered, his application, pending application for regulation of his land to be considered. And another is, over that land, this so-called notice has been issued. Accordingly, on the appointed date, the petitioner went to the office of this state officer on exactly on that day, 25/11/2020, on 1200 hours. He went there, but there was no proceeding there. So, being a layman, on 24 of, in the annexure 6, 24 of 2020, page 24 of the WP, annexure 6, he has filed an appeal matlab, that is a request, to my understanding, to the deputy commissioner. Appeal means request, saying that I have occupied such and such plot of land. I have been that has been that is liable to be regularized, this and that. One application has been written, and that without properly completing that eviction process, without passing any order under 5, 6, and 7, 5, 7, and 8 of this law, this as per the Eviction of Public Premises Act, that there is a body called in the Pasigat, in the district-based state officer come demolition officer body. They have constituted a body of the officers to demolish whoever have that constructed illegal structure. So they are trying to destruct directly to the without properly hearing. So at this stage, I would pray for the deputy commissioner concerned to direct the deputy commissioner for disposal of not the appeal but my representation.
Your representation pending before?
Yes, before the deputy commissioner. Page number 24, annexure 6.
But you have filed a reply on 16th May to the
Yes.
so-called notice.
16.
Page 7 of the affidavit.
It is page 7 of the affidavit.
Affidavit filed by petitioner.
Yes. It is during the course of this court proceeding, I am told that you have not complied the procedure under the law because you have not filed any.
So what happened to this so-called notice under section 4?
That is why I have.
Let us do one thing. Let the process be completed before the state officer.
Yes.
And we'll say that if he's agreed, we can go to the
Yes.
appellate body. Because see, if you see page 24, it is not as such an appeal.
Yes.
It was against the notice.
Against the notice.
At least
he
the
had
notice.
gone
So
to
it cannot be treated as an
Yes.
appeal. It is against the notice. However, in the meantime, during pendency, he has submitted the so-called reply.
Yes.
So therefore, let the so-called reply be decided by the state officer. Then thereafter, if it is agreed by any decision
Yes.
by state officer, he will be at liberty to proceed as per law by preferring an appeal, not this court.
That may be law.
Let him a chance. Who is layman? You are not a layman, you are an engineer.
Not at all, Lordship.
Huh?
Not at all.
Not at all layman, don't say that ground. Then we'll ask the state to how they are keeping a layman in
This is
service.
within the very
Electric
important
colony,
office
electric-
area, Lordship, this, where he have.
Now who is
quite-
in the possession of the land? Demolished already.
I'm I'm in position of the.
Why it's happening everywhere inside the office? You are retired officer or what?
No, I'm not an engineer. This is SE electrical colony. And the colony, not the SE, not the engineer. SE electrical colony, high region area. I'm a
You are
layman.
inside a colony.
Yes.
Not area is colony, but
So let us not comment on, let us circle officer evicted. You have no way out but to get evicted.
Instruction
I
I
may
have
be
brought
allowed
also,
to-
Lordship.
Huh?
He-
See, if
Instruction
it
I have
is,
brought
if,
also.
huh?
Instruction I have brought also, Lordship.
Okay,
But
no,
we have
you
not filed, but.
you have the instruction.
Lordship,
The learned state council submits that she may be granted some time to obtain to complete her instruction and file an affidavit if so advised. Prior is allowed, list accordingly. You give a details whether land is, there is any LPC, land is to the state, then why should we entertain? See, even if assuming there are two aspects, since you have come to this court, one aspect is violations of principles of natural justice, and other aspect is show us, we'll decide what is your right. If the land belongs to a state department with LPC and all, why should we entertain this kind of petition?
Lordship, what we have said is on the given that
Okay,
she had appeared, but then she could not bring anything. Any
But there is no
documents.
specific order by the,
Same.
no specific order by the state officer. Problem is this.
In my instruction, Lordship, she came for the hearing.
No, that
Lordship,
we
but then-
understand. She came to the hearing. Let us understand.
Yes.
But where is the order of the state officer? Problem is this. There must be an order of the state officer saying that we have heard you.
Say so, Lordship. Consequently, the state officer passed an order.
Where is
under-
that?
Lordship, this is
The order is of the deputy commissioner rejecting.
no, Lordship.
If there were any such
That
order.
you have received it, no, is it available on the record in his pleading or your
Yes, sir.
instruction?
Yes, Lordship, we have not filed the.
Therefore, you file it.
Lordship, his enforcement photograph
Ah,
also
that-
inside
that-
the Lordship.
That you file an affidavit.
He is building Lordship. Construction is
Annex
going on.
3, Annex 3 of the.
Annex 3. It's yet to be filed.
That's what I'm saying. You'll have to file it, bring on record, then we may dismiss this petition.
Yes,
Saying
Lord.
that nothing doing, because this will sending you back to the circle officer will be an empty formality,
Yes, Lord.
isn't it? Earlier order, that list is on the prayer of complete dictated an order. That's it. Call it. Yes, Makatu, what is this?
Well, my simple case is first allotment.
Yes, respondent counsel is present.
My senior is engaged in court number 2, so he is unable to present today.
List this matter on 19th. On the prayer of the learned counsel for the respondent number 4. Full stop. Inasmuch as the learned counsel for the petitioner has expressed an urgency in this matter, okay?
On 16.
16 is difficult proposal.
Tomorrow, my lord.
See, one of the private secretary has left because of his son is seriously ill today morning. So 16th, I will have to complete, correct, upload everything this. So therefore, I am saying, otherwise I will not have said no.
Tomorrow, my lord. Well, normally, my lord, we are not getting defenses.
Tomorrow.
Defenses with your lordship. So therefore, every time we wanted to do our case before your lordship.
That has created 7 CCAVs. That is to be completed. Okay, list is tomorrow. Keep the. Be prepared to ask your senior. The only limited issue is whether after a determination is made in an earlier proceeding, everything was completed, whether you are within your competence to pass an order cancelling the LPC and whether any hearing was given to him. That's all. According to him, it is behind his back. There is a show cause, but he has not been given.
In fact, we given our statement, but that was not taken into consideration. On the later stage, my lord, the order has been passed by behind the my lord, back of petition.
So that's all. Who is in the possession?
My lord, as per the order of this honorable court, the status quo is unknown.
But you are not in possession, seems.
My lord, there is a state.
The disputed land is very nearby my center. It is not in the position of the petitioner.
It's your personal knowledge.
My lord.
Then we'll have to call him in a box To depose my lord. Yes. That's all?
May I please, your lordship?
Yes.
Your lordship, item number 32 of today's list, your lordship.
Item number 32, what order we have passed? After 2 weeks. Want a date?
Yes, your lordship. If it is fixed on 5th of September, it will be.
15th of September. Okay. Mr. Sharma is virtually present, huh?
Yes, sir.